Meine sehr geehrten Damen und Herren, herzlich willkommen bei unserem Webinar zum neuen Energiepaket in Serbien. Mein Name ist Erika Theoman-Brenner, ich bin die österreichische Wirtschaftsdelegierte am Außenwirtschaftscenter Belgrad. Serbien hat sich verpflichtet, bis 2020 27% seiner Energie durch erneuerbare zu generieren. Das heißt, es gibt viel Investitionspotenzial. Dazu brauchen wir aber klare Rahmenbedingungen und die sind durch dieses Energiepaket jetzt geschaffen worden. Wir werden Sie heute informieren über Einspeisetarife, gesetzliche Obergrenzen und vor allem auch über die Stromabnahmeverträge, die ein Kernstück dieses neuen Gesetzpaketes sind. Abgerundet wird unsere Veranstaltung auch durch einen steuerlichen Teil. Hier erfahren Sie wichtige Aspekte, wenn Sie Komponenten oder Anlagen nach Serbien liefern wollen oder wenn Sie sogar auch daran denken, in diesem Zusammenhang eine Niederlassung zu gründen. Durch die Veranstaltung führen und moderieren wird Fabian Gems, stellvertretender Wirtschaftsdelegierte hier in unserem Außenwirtschaftscenter.
Sehr geehrte Zuseherinnen und Zuseher, auch von mir ein herzliches Willkommen bei unserem ersten Webinar in Serbien. Das ist auch für uns eine spannende neue Aktivität, die wir setzen können, um Sie so rasch als möglich über die neuesten Entwicklungen in Serbien zu informieren. Auch haben wir hier die Möglichkeit, mit unseren Experten gemeinsam mit Ihnen zu diskutieren. So würde ich mir wünschen, dass Sie das Tool auf der rechten Seite nutzen und uns auch schon während der Präsentation Fragen schicken. Alle Ihre Fragen werden natürlich beantwortet und zögern Sie auch nicht, diese in Deutsch zu stellen. Wir übersetzen die gerne. Die Vorträge werden von unseren Experten vom CMS Belgrad präsentiert. Zu meiner Linken habe ich Frau Ivana Blagojevic und genauso zu meiner linken neben mir sitzt der George Popovic. Beide gehören zu CMS Belgrad. Es ist eine Filiale, ist ein Branch von CMS Reich Heinz und gilt mit einem Team von 25 Anwälten als eines der führenden Anwaltskanzleien von Serbien. Und gerade im Bereich Energie und Steuer gibt es eine große Expertise und deswegen haben wir uns auch entschlossen, gemeinsam mit CMS dieses Webinar zu veranstalten. Noch ganz kurz zur Frau Ivana Blagojevic. Sie ist Senior Member der Steuerabteilung von CMS Belgrad und sie berät ihre Klienten in allen Teilen des serbischen Steuerrechts. Aber ihre Expertise deckt sich nicht nur auf indirekte und direkte Steuern, Steuervertretung und Compliance-Lösungen, sondern vor allem auch im Energiebereich. In ihrer mehr als 14-jährigen Tätigkeit als Steuerberaterin ist sie natürlich auch in allen ihren Fragen, die sie genau zu diesem Bereich haben, bestens ausgerüstet, um diese zu beantworten. Und zu meiner Linken, Herr George Popovic, ist Rechtsanwalt mit 10-jähriger Erfahrung und Leiter der Abteilung für Energierecht. Er spezialisiert sich dabei vor allem auf erneuerbare Energie und Energieeffizienz und vertritt dabei sowohl Investoren als auch Geldgeber und hat sie auch vertreten in den prominentesten Transaktionen des Landes. Und genauso hat er auch an der gesetzlichen Gesetzestätigkeiten mitgewirkt und hat dort bei der Harmonisierung von serbischem Recht mit EU-Recht tatkräftig mitgearbeitet. Die Präsentationen werden auf Englisch halten, deswegen werde ich auch Herrn George Popovic das auf Englisch vorstellen. Without further ado, I would like to give you the virtual floor, because we don't have an actual. Thank you very much.
Thank you very much, Mr. Jansen, Mr. Brenner. So, dear ladies and gentlemen, we are very happy to be part of this webinar and very happy to share our views on this very relevant topic for the energy market in Serbia and in particular for the renewable energy market. We would start with the presentation of the new energy package that was adopted quite recently, that happened in June this year, and is just about to commence. The projects are just about to become operable, so we thought it would be very useful to discuss certain legal and tax aspects of them jointly with you. So as stated, we are very open to your questions and comments and are happy to discuss relevant things and issues with you. To start with, let's say that Serbia has really waited for a significantly long period the comprehensive set of regulation that would regulate the renewable energy production and transactions. And it was the result of the 2-year-long debate, very detailed one in certain aspects, among the relevant stakeholders. Namely, unlike in some other areas, in the renewable area, the government of Serbia really showed a sufficient amount of willingness to discuss openly the relevant issues and to be able to hear the actual requests of the stakeholders and to discuss them jointly with them. As a result, we got the PPA package, which is, in our view, and at least on the face of it, feasible and bankable, and able to finally allow for the projects to start operating. Now, let us start with elaborating or just briefly stating on what the actual pieces of legislation, this PPA package, as we call it, is consisted of. It is actually consisted of the 3 decrees that were adopted by the government in June 2016, and these 3 decrees are interrelated to each other because all 3 of them actually regulate specific aspects of the same matter, renewable energy projects. The first one is formally named Decree on Incentive Measures for Electricity Generation from Renewable Energy Sources and High Efficiency Generation of Electricity and Heat, or shortly, Incentive Decree. Basically, this is the decree that puts forward the set of incentive measures available to renewable producers and further mechanics on how to achieve the entitlement to such measures. The second one is the decree on conditions of and procedure for obtaining the status of a privileged power producer, preliminary privileged power producer, and producer from renewable energy sources, or to put it shortly, the status decree. So the status decree regulates the manner in which these 3 statuses could be obtained, could be upkept, and could be prolonged in certain situations. And it also covers certain very specific situations that are relevant for investors in terms of interrelation with the construction aspects of the renewable projects. And last, but definitely not least, Decree on the Power Purchase Agreement, or abbreviatedly the PPA decree, is a decree that actually prescribes the model of the PPA. So the PPA stands for Power Purchase Agreement. The model meaning also the mandatory elements of the PPA and the aspects that are related to entry into such agreement, upkeep of such agreement, and related legal consequences. So this would be these 3 decrees: the incentive decree, the status decree, and the PPA decree are the pieces of legislation that constitute the PPA package. As stated, they are interrelated to each other in our view, pretty consistent manner, and there are still certain challenges ahead, and we would also, while presenting the positive sides of the package, we will also address certain challenges that are pending and that are yet to be solved on the market. We will start with the incentive decree, which, as briefly mentioned, regulates the main incentive measures available to the renewable energy producers. First of all, the first measure is actually the very incentive period, which is the term under the PPA agreement and is principally set to last for 12 years as of acquisition of the privileged power producer status. So basically, it should be kept in mind that as of acquisition of the power producer status, the 12-year period for the during which the incentive price for electricity can be achieved will last for 12 years. The second incentive measure is the very incentive purchase price, i.e. the feed-in tariffs or FITs that are prescribed at different levels depending on the type of the generation facility, and being also dependent on the prescribed maximum annual effective operation time for different plants. These feed-in tariffs levels vary, and we will come to a little bit greater detail on that topic just in a minute or so. The third incentive measure is the undertaking of the balancing responsibility during the incentive period, which is set to last for 12 years, by the guarantee supplier or by the off-taker. Now, just to be sure that we understand what actually the off-taker stands for, the off-taker is the guaranteed supplier, i.e. the public company, which is a subsidiary of the Serbian company EPS, being the incumbent in the electricity distribution and to some extent generation. So this is the public company named EPS Snabdevanje d.o.o., which is under the law obliged as a guaranteed supplier to purchase electricity from the renewable energy producers. So when we speak about the off-taker, we are actually referring to the guaranteed supplier or to the EPS Snabdevanje, which is the public company. So the third incentive measure is undertaking of the balancing responsibility by the off-taker. That actually means that all the liabilities related to the balancing of the system, which is quite important topic relevant for the taking over of electricity and its delivery in the system, is something that is the liability of the off-taker. The fourth incentive measure is also the undertaking of the balancing costs by the off-taker, which effectively means that the public company purchasing the electricity will be in charge of paying any costs associated with the balancing on the system during the incentive period. And lastly, there is the free of charge access to the transmission or to distribution system, which is the fifth incentive measure, and also very important one, knowing that in the past the access to the system was subject to administrative fees. Now it shall be free of charge, and this is something which is guaranteed to the renewable energy producer who have acquired the privileged power producer status. Now, on the topic of the very privileged power producer status, we would like to state that actually the relations differ between two of them. One is the preliminary privileged power producer status, or to put it more briefly, we could call it 4P status, which is the status that should be obtained in the early phases of the projects while the facilities are already still being built, and up to the moment of actual connection to the transmission or distribution system, where the regular privileged power producer status should be obtained by the generator. So we will call, to avoid any confusion, we will call the privileged power producer status the 4P status, and we will call the regular permanent privileged power producer status the 3P status. This being said, we can go to the further incentive decree, which introduces the so-called maximum annual effective operation time for all types of the generation facilities, which are being kept and included in the calculation of incentive purchase price. What does it actually mean? That it actually means that currently in the law, we have the maximum time of operation prescribed differently for different facilities, which should be the maximum operation time under which, for which the incentive purchase price could be paid. These maximum operation time thresholds are set effectively in a way that they will more or less cover the expected actual capacity of the facilities on the market, meaning that it is expected from knowing the current projects of the market that approximately 97% of the overall operation time of the generating facilities will be actually covered by the regular feed-in tariffs, where only 3 or 4% are expected to be in excession of such statutory limits. And the regulation further states that even if the maximum effective operation time is exceeded by the generator will still be entitled to the 35% of the regular feed-in tariff for such excession or for such exceeding of the mandatory thresholds. When it comes to very incentive prices, i.e. the feed-in tariffs, they differ as per the relevant facilities and are prescribed in different levels. For example, they range between 6 euro cents per 1 kilowatt hour for hydropower plants on existing infrastructure to 9.2 euro cents per kilowatt hour for wind power facilities to 13.26 euro cents per kilowatt hour for biomass plants up to 1 megawatt of installed power, and so on. If needed, and if there is an interest, in the further discussion, we can go to other prices for other types of facilities. We have this regulation with us here, so we can go on further details on that if needed. What is also important to note when it comes to the incentive decree is that all these feed-in tariffs are indexed according to the Eurozone inflation. In other words, there is the comprehensive formula in the incentive decree actually allowing for the adaptation of the incentive price to reflect the modifications of the inflation in the Eurozone. And basically, something which is very important for the renewable project is the fact that the incentive decree prescribed that even if during the 4P status, which means in the preliminary phases of the project where the facility is not yet fully tested, not yet fully permitted, and therefore the regular 3P status is not yet fully acquired, there is the possibility to buy electricity under incentivized prices during such commissioning. Why is this important? This is important because from the technical viewpoint, it is sometimes, especially in the projects of large scale, technically not possible to commission and test, i.e. put in the trial run the entire facility all at once. For example, in the wind farm project where we have 20 or more wind turbines, it is not technically possible to put all 20 turbines or more at once in the operation. And during the real estate permitting, it is quite essential part of the final technical acceptance procedure that the facilities are being tested, i.e. Actually connected to the system. When they are actually connected to the system and they need to be put into operation in phases 2 by 2 per 1 week in case of wind turbines, most commonly, that will mean that there will be a stream of energy during such partial testing coming into the system, and if there were no incentive prices for such situation, that would actually mean that the generator is not entitled to incentive measures, and there will be a huge amount of electricity actually sold either under the current market prices or even with no consideration. So to regulate that and to meet some of the stakeholders concerned during the drafting process of this regulation, the government adopted the solution in the incentive decree according to which during the 4P status, during the commissioning, there will be the entitlement to the 50% of the regular feed-in by the generator. Once the entire facility is tested, the generator will get the entitlement to the full feed-in tariff. But at least during commissioning, he will be entitled to the 50% of the actual feed-in tariff. There are other two things that are very important to be mentioned, that are introduced as a very significant novelties in the incentive decree, and they are also reflected in the other two decrees as well. The first One is the so-called political force majeure. Namely, usually and so far in the Serbian legal system, there was a traditional force majeure. And it was usually even not prescribed specifically in the specific regulations, such as those that regulate the energy projects. It usually was relating to the natural catastrophes, earthquakes, acts of God. However, the government showed willingness and understanding of the stakeholders concerned about the inefficiency of the Serbian administration that had occurred previously in the practice on multiple occasions, and they have now allowed the possibility to invoke the political force majeure in case that any authority fails to issue any permit or license or other public authorization on time, or it fails to issue it at all, or it wrongly issues, or it cancels for no reason. So in such situation, the incentive decree basically protects the generator and states that the generator will be entitled to invoke the political force majeure and request for prolongation of his obligation if any state authority actually in the complex permitting process, such as the renewable projects, it will prolong his obligations up until such permit is being finally obtained. Second important novelty is the one related to the change in law, namely to address certain considerations and unfortunate experiences in the region, the examples being Bulgaria and Romania, where the government was very enthusiastic in the first stages of the renewable projects, but have subsequently either reduced the feed-in tariffs or have imposed additional obligations, and that effectively meant that the generators are entitled to the lower incentive measures than initially promised. The government now introduced very comprehensive change in law clauses in the regulation, which basically aim at putting the generator in the same economic and financial position it would have been had the negative change of the law never occurred. So in simple words, once the PPA is signed, once the project starts running, if the state adopts further regulations which effectively result in the generator being in a worse economic position it used to be before the project, which affects also the incentive tariffs, there is the contractual illegal mechanics for the generator to request to be put back in the same economic and financial position it was initially, which is also very important feature and very important and brave, I would dare to say, novelty that the legislation has brought about. So these are the main features of the incentive decree. There are certain downsides too, and maybe in order to save time and go to the main aspects of the other two decrees, we won't spend much time on it, but we will be happy to further elaborate it during the session. One of the major downsides are that some rules are not fully developed. So, for instance, speaking about the change of law, there is actually, there appears to be no statutory mechanics for the generator in case the government fails to decide on his request for the change of law. So there is no precise procedure to govern such situation, which means the generator needs to evoke general rules of the Serbian administrative law, which is possible, but it would have been better should this sort of situation was explicitly regulated in the decree. Okay, we are now going to the second decree, which is the status decree, and this decree basically prescribes terms and conditions for obtainment, upkeep, and cessation of the 4P status, being the preliminary status, of the 3P status, being the regular privileged power producer status, and of the renewable energy producer status, which is the status, by the way, that provides the right to be to have the access to the system, but has limited possibilities when it comes to incentive prices. So this is some sort of the green energy producer status that apply to generators that are not eligible for the privileged power producer status, but still have certain advantages and certain entitlements in regard to the connection to the grid and selling of their green energy. Basically, the status decree provides for a rather comprehensive set of rules in terms of obtainment of these free statuses, but also in terms of prolongation of these free statuses. Why is this important? It is very important because currently on the market, there are many generators that have obtained the 4P statuses. As we stated in the beginning, it took government more than 2 years to finally adopt this PPA package. That created significant uncertainty for the generators and significant complications when it came to financing of their projects. Now that the projects finally become operable, there is obviously a need for additional time for the generators in order to put their transactions together to agree on financing of the projects with the banks and other financiers, which requires additional time for the generators to be able to timely get to the regular status and selling of electricity under the incentive feed-in tariffs. The status decree now prescribes that in the event that the 4P status initial term, which is set to be 3 years, needs to be prolonged, the generator will be entitled to 1 year prolongation of such status, and to do that, it's not required to get connected to the grid. So in other words, the generators now who have obtained 4P status will have 3 years from June 2016 or from the moment when they acquired initially the 4P status to construct the facility. If they need additional 1 year to get connected, to go on the trial run, they will be entitled to 1 year prolongation. And in order to be entitled, they just need to show that the facility is being built. They don't need to connect the facility, and they don't need to undergo to any other specific procedures, which is quite important from the perspective of the bankability of projects. Also, there is the possibility to prolong the 4P status based on the political force majeure too, which is also very important because it indeed may happen that along the very complex permitting process, some authority simply fails to timely issue the permit or fails to issue a permit at all. So in such case, the generator should not be in a position to have negative consequences of such government failure. So he would in such case be entitled to specific prolongation on that basis for as long as political force majeure lasts, which could be 1 year, 3 months, 2 years, depending on how big is the delay by the government to adopt the permit or to issue any other relevant authorization, which is also very, very significant matter and also represent a sort of government's pledge to allow for these projects to finally happen. Lastly, on the status decree at this point, is that basically, as was previously the case, it provides for certain statutory caps applicable to certain facilities which are expected to generate green energy. Namely, so at present, there is the 500 megawatt statutory cap for wind energy. That means that only projects that have obtained the 4P status and have overall capacity altogether up to 500 megawatts will be entitled to feed-in tariffs. All others will have to wait for this cap to be increased. The same cap is prescribed for the solar energy and amounts to 2 megawatts for rooftop solar of up to 30 kilowatt hour, and up to 2 megawatts for rooftop solar between 30 kilowatt hour and 500 kilowatt hour, and finally 6 megawatts for ground-mounted solar up to 500 kilowatt hour. So basically, currently in the market, we are safe to state that all these caps actually have been reached. And any new generator in wind or solar energy that would like to go on the incentive prices and to become the privileged producer will either have to buy the project from the existing holders, or will have to wait for the 4B status holders to fail to meet their deadlines or to abandon the projects. It is generally expected that these caps are being increased in the foreseeable future. Government stipulating and publicly pledging to do that in a couple of months' time. However, such an increase would have a significant impact on the overall state policy on the electricity market and the prices. So it really yet remains to be seen whether this will actually happen. But for you, at the moment, to take away from the status decree, it will be important to know that for wind and for solar, there are statutory caps, which are actually in the market already being reached. Lastly, in this introductory part in this first presentation, we would focus on the PPA decree, which is, let's say, the main actually document that regulates the relations between the privileged power producer and the off-taker, which is the public entity. As stated, the PPA agreement can be concluded between the holder of the 4P status and the public off-taker. What does that mean? That actually means that even in the early phases of the project, where the facility is still being built, there is the possibility to enter into the PPA with the off-taker and to transit, to move towards the 3P status, the regular status, during the PPA, meaning that the generators get the safety, the security. They are sure that their PPA is already in place, although they are not yet having the regular status. This is quite important possibility because the banks and other financiers will typically want to be able to be assured that the PPA is actually concluded, although the generator still does not fulfill all the conditions required for the full feed-in selling of electricity. Also, the PPA model that is part of the PPA decree, so the model of the Power Purchase Agreement, contains clauses that are quite advanced compared to the previous regulations. First of all, they also contain the political force majeure. So, the generator, in case any authority fails to issue timely any permit necessary for the project, will be entitled to prolong fulfillment of its obligations under the PPA until such authorization is finally issued. Secondly, there are comprehensive provisions governing the adverse change of law in the PPA model, which actually again means that the generator will be in a position not to bear detrimental consequences in case the government at a later point adopts certain measures that deteriorates or put in a worse position the generator. Moreover, there are the provisions in the PPA that concern the dispute resolution in a more, let's say, international manner. Namely, now there are the provisions that state that there are two possibilities for the international arbitration. Either the International Chamber of Commerce, seated in Paris, and the rules of such international arbitration, or the rules of Vienna International Arbitration Central, seated, of course, in Vienna, which is also, from the perspective of the generator, additional possibility in order to be able to have such a complex overall contractual setting in case of dispute being actually resolved by the reputable international dispute resolution venue. There is, again, the possibility to have the step in by the lenders in the position of the generator in the PPA decree. This is available for the projects having more than 30 megawatts in power. This is also very important because the lenders typically want to be sure that they are able to step in into the project in case the generator defaults in delivering his obligation. Now we have a separate step-in model attached to the PPA model in the PPA decree, which regulates such situation, which is also a positive step forward. There are also some challenges. The main challenge in the PPA decree is consistent in the fact that instruments of security or collaterals to be provided by the off-taker to the generator in case the off-taker fails to pay timely or fully the incentive price, the feed-in. There is now basically only one collateral prescribed under the PPA model. That collateral are the promissory notes. So the model states that the off-taker shall issue the promissory note to the generator to guarantee for fulfillment of his obligation. The main one is to pay the feed-in tariffs or the prices to the generator. This is fine instrument in times when there are sufficient amounts and funds on the account of the off-taker, because this instrument is very fast to enforce. The procedure of enforcement is rather straightforward, and it makes certain comfort for the generator. However, in cases where there are no sufficient funds on the account of the off-taker, there is simply no way to enforce the promissory notes. So in such situations, the generator will be obliged to go at a regular route of enforcement, going to enforce against the entirety of the property of the off-taker. To avoid this to happen, the PPA model should have prescribed that in large-scale projects, there would be the bank guarantee, because the bank guarantee is, of course, the security instrument which hedge against the risk of the guarantor not having sufficient funds, because in such a case, the bank will be obliged to the due amounts. This is something which is still lacking in the model. However, there is the possibility to have this remedied by way of exception. Namely, the PPA decree prescribes that the rules of the model PPA are obligatory, but the generator in specific cases may request from the Ministry of Energy to put in additional provisions in the PPA if the specific situation so requires. In our reading and in our understanding, in projects of large scale, there should be a possibility for the generators to come to the Ministry of Energy and request the bank guarantee to be included in the PPA model. Whether this will eventually happen depends essentially on the willingness of the Ministry of Energy to meet the concerns of the lenders and to allow for the projects to be fully bankable in case the lenders will require from the generator to be provided with the bank guarantee by the off-taker. So these were the remarks regarding the PPA model and the other two decrees. There are other very important aspects to be considered, especially from the perspective of the suppliers of equipment and contractors. And we are aware that the audience of this webinar is predominantly based in construction business or the supplier business. So just to finally conclude that we will be happy to meet any other topic and to discuss it that relates to the aspect of the suppliers relevant for the PPA models. We are happy to develop discussion on this topic, and I will be very happy to hand the word to my colleague Ivana Blagovic, who will go in the analysis of certain very important tax aspects of the renewable projects.
Thank you, George. I will present to you only a few interesting moments that can occur developing an energy project in Serbia. And let's just start from this very beginning. Foreign investors usually were planning to enter a new market, or usually start with analyzing how they will finance their project, the intended project, and all with a special consideration on the exit stage, once they will maybe leave the market, and that would be another important moment that should be taken into consideration upfront. Now, for the energy projects, there might be three traditional ways of financing them. One would be through equity interest, through share capital in a Serbian subsidiary, where the investment would return through naturally dividends. The interesting tax aspect of dividends would be, of course, the withholding tax on the dividend received by the foreign shareholder. Serbia has a quite wide network of double tax treaties, whereby when there is a shareholder who qualifies for the application of one of the double tax treaties, the statutory withholding tax rate from 20% can drop to as less as 5%. The double tax treaty between Austria and Serbia prescribes for two alternative withholding tax rates, which are both below the statutory 20%. And those are the 5% withholding tax rates on dividend paid to a shareholder who is an Austrian corporation, meaning a GmbH or AG. And in all other cases, a 15% withholding tax rate applies. And that would be in case the shareholder of the Serbian project company, energy company, would be a partnership. Alternatively, the project could be financed through loans. This is a much more flexible way of financing, considering that unlike the share capital, loans can be also granted by third parties and financial institutions. The return on the investment in this way would go, of course, through interest. And then again, the tax aspect of paying interest from a Serbian company to a borrower abroad. It would, again, a 20% withholding tax rate would apply on the interest unless a double tax treaty would apply. In this case, the tax rate could drop to even zero. And in case of an Austrian lender, that would be a 10% withholding tax rate of the interest paid by a Serbian company abroad. The withholding tax on interest is not the only concern when it comes to loans. In case the loan agreement is concluded between the Serbian company and a related party, meaning that its shareholder or a sister company, transfer pricing regulations must be taken into consideration. The applied interest rate between the borrower and lender could be either documented through the traditional transfer pricing documentation, or contract parties in a loan arrangement could also go for safe harbor rates, which are prescribed annually by the Serbian government. So also the contracting parties can agree to stick to prescribed rate, which would eliminate then the of benchmarking in a transfer pricing documentation. Another issue with the loans, when it comes to loans between related parties, is also the debt to equity ratio, the capitalization rules. Namely, the interest cannot exceed 4 times the equity of the Serbian company which is borrowing the funds. That would go for the loans. There would be a third option for the financing of the energy projects in Serbia, and that would be additional payments. Additional payments are a very useful means of financing the company, yet its downside would be it does not make any return on the investment. Namely, additional payments can only be granted by the shareholder of the company, and no interest can be charged on them. They're not equity capital, they're not registered with the Serbian Business Registers Agency, and not being a loan, they're not registered with the National Bank of Serbia. Their pros are the fact that they're very easily transmitted to Serbia and to the company needing financing, and relatively easy paid back, but in the nominal amount as received.
Yeah, so just to add, so basically additional payments do not formally increase the share capital.
Do not. So
Sure.
they're just there to. Usually in practice we see them. As a fast means of getting funds and liquidity to the Serbian subsidiaries. As to the exit stage, this is also usually considered by shareholders when entering to a market. Namely, the question about the exit stage is what when I sell my shares? How will I be taxed on my capital, on a potential capital gain that I will generate in Serbia? Basically, capital gains are taxable in Serbia in case there are no double tax treaties between the country of residence of the shareholder and in Serbia, in which case a 20% withholding tax applies. In case there is a double tax treaty between Serbia and the country of residence of the shareholder who is exiting the project, again, two options are possible. Either the double tax treaty gives the taxing right to the country of residence of the shareholder in any case, in which case no taxation takes place in Serbia, or the double tax treaty can give the taxing rights to Serbia especially in situations when there is a so-called real estate clause. What does this mean? A real estate clause is a feature of the double tax treaty between Serbia and Austria. Usually, all the capital gain that is generated by Austrian investors in Serbia from sale of shares, equity interest in Serbian companies, etc., is taxed in Austria. But in case the company that is sold, in case its equity consists predominantly of real estate, such capital gain of such an Austrian shareholder will be taxed in Serbia, again at a statutory rate of 20%. So it is very important, even in the initial phases of planning the Serbian project, it is very important to note and to plan what will be in the company, what will be its operations. Will the company have any assets in Serbia? And if yes, how will then the shares of the company be disposed of? Now that we have established the companies, the energy company, it will need to have suppliers in Serbia. It will have to establish its operations. Namely, the suppliers of the Serbian generators can and will supply a wide range of goods and services to the Serbian generators in Serbia. All these supplies will be subject to Serbian VAT, since most probably all of these supplies will have the place of supply in Serbia. Now, depending on the place of residence of the suppliers, we will have a situation that the generators in Serbia will have either local suppliers or foreign suppliers or contractors, which will impact different VAT compliance rules. Namely, in case the Serbian generator receives supplies from the local contractors, so local Serbian companies,
even if they are subsidiaries of foreign companies.
Even if they're, so as long as they're registered in Serbia, all supplies of these local contractors will be subject to Serbian VAT. This is not non-questionable. Question is, who will be the person liable to pay VAT? In most cases, the person liable to pay VAT will be the supplier. So the Serbian generator will just deduct that VAT from its own VAT liability. Or in some cases, the generator will be the one who will actually be the person liable to pay VAT. For these situations, the Serbian VAT Act provides for the local reverse charge. Most commonly, this situation will take place in which the generator will have the obligation of the local reverse charge in construction works. Since the general rule is that persons liable to pay VAT on supply of construction goods and services is the recipient of goods and services, as long as both parties in the supply, the supplier and the recipient, are VAT payers. So the taxable person is registered for VAT in Serbia.
Maybe just on the mechanics, the reverse charge. I mean, it's something that is perceived as favorable, but maybe for those attendees who are not aware, just a brief explanation.
Sure. Yeah. Okay. In usual situations, when you have a local Serbian company that is supplying water, bottled water for the staff of the generator, there will be an invoice with the VAT of the supplier, and that VAT would be fully deductible by the generator in its own tax return, VAT return. On the other hand, when we have the supplier being a construction company who is providing whatsoever construction services, the construction company will only issue a net invoice with only a net amount charged for its services. On the other side, the generator, as the recipient of the services, of these construction services, will have to calculate, instead of the supplier, its VAT, which will be at the same time, in the same tax return, be the obligation. So the net effect of it is zero. It's only a compliance exercise in the VAT books and VAT tax return. Correct. Now, a good thing is that since recently, not only locally registered suppliers can supply goods and services in Serbia, but also foreign contractors. Namely, up until now, we had a situation that a foreign contractor, that would be a company registered abroad, registered in Austria, could not act as an importer to Serbia. And that was really an issue because more than often we've seen in practice that, for instance, big Serbian companies were announcing tenders and giving away tender agreements, public procurement, etc., for the acquisition of a certain delivery of goods, usually rarely services. And when it it comes to goods, it was a problem that usually the Serbian company would request complete delivery of the goods to Serbia, practically to its parking lot, and the Serbian company would never want to deal with the customs, would pay the customs invoice, etc. It was only aimed at giving away a certain gross amount of the sale price it was ready to pay. That caused amazing issues in practice, because if we have an Austrian company that would like to sell the requested goods to the Serbian company, the question was, who would first import such goods to Serbia? Then the Austrian company would have to either mandate and to contract an existing Serbian business partner in Serbia to act as importer on record for that goods, or even open up a subsidiary in Serbia, its own subsidiary, which would then import the goods. Form of its existence registration in order to comply with the obligations in that agreement for the Serbian recipient of goods. Now, since recently would be not only since the amendments of the Serbian VAT Act, but also since May this year, when the Ministry of Finance issued a publicly accessible explanation, foreign contractors can finally sell, import to Serbia, and supply in the Serbian market goods. In order to be able to do that, a foreign contractor, an Austrian company, must take a couple of steps in order to be able to import goods to Serbia and then to supply these goods to, for instance, the Serbian generator, the energy company. First of all, the Austrian company will have to appoint a Serbian VAT representative, fiscal representative. This VAT representative will, in the first place, register the Austrian company for VAT in Serbia. So basically, the Austrian company is getting a VAT registration in Serbia. And only after these first two steps have been made, the Austrian company would have to appoint a Serbian customs agent who will then be able to import whatever goods are sold to the Serbian generator. Under these conditions, the foreign contractor, as of now, can supply fully independently the Serbian recipient without any help of its subsidiary, its branch, or another Serbian business partner. This is now allowed and technically possible. Everything said here is relatively new. We may still experience and expect difficulties, but main thing, the practice does develop, and there are open doors for foreign suppliers to perform the supply in Serbia on their own. In case this is, of course, necessary in accordance with the contracts. Appointing a Serbian VAT representative and registering for Serbian VAT is still not an obligation, it is only an option. So whenever necessary according to the planned transaction and necessary for the foreign company, registering in Serbia for VAT is possible. Now, okay. Well, some of the generators do have some real estate, some land plots in their ownership, as I understand it, right?
I maybe just briefly explain that. So basically, there was a huge amount of ambiguity whether the generators will be able and allowed to have ownership over the parts of the grid in energy projects. based on the new solutions of the energy law, generators now may opt, subject to their own discretion, whether they want to build the grid on behalf of the operator. The thing is, the grid, being part of the transmission or distribution system, needs to be publicly owned, and it needs to be managed by the relevant distribution or transmission system operator. What does that mean in the real estate terms? That means that formally, the operator, i.e. the TSO, the DSO, the public entity, needs to be formally the owner of the grid. And as such, it needs to be formally designated as the investor in the construction permit. Now, because there was ambiguity in the Serbian energy practice, whether and to what extent the generator may affect the construction of the grid, some notable number of generators did already buy the land necessary not only for the energy projects, for example, the solar project or the wind farm, but also the land necessary for the positioning of the grid. And when I say grid, I mean the high voltage part of the transformer station and lines that go up to the transmission or distribution system. Now, they wanted to do that, the generators, because they didn't want to risk of, price for land going skyrocket, so they wanted to purchase the land. But now, formally, even if they're constructing the grid by engaging the EPC contractors and so on, they need to legally transfer it to the operator. And they want to do that free of charge. So, just by way of introduction, this is where the issue legally stands for. And now we go to the tax aspect.
Yes, in this slide, the tax aspect has its own issue as well.
Mm-hmm.
So that we have a situation that some of the generators will transfer the land they own to the operator. And they will also sponsor the construction of the energy facilities of the grid.
Mm-hmm.
Correct. Sorry. Now, it is envisaged that both of the transfers, but the supply of land and the supply of this construction will be provided free of charge. Now, the question is actually, will this really be free of charge?
Of course.
Yes.
Tax-wise.
Tax-wise, correct.
Mm-hmm.
Because the generators, they will be charged beneficial prices one day in the future by the very operator,
Mm-hmm.
And that will happen in return of the transfer of the land and the financing of the construction works. Now the question is, if there is something in it in return, is this really free of charge or maybe a barter agreement? Now, at this very stage of the development of our tax laws and tax practice, the situation is not fully clear. Namely, there is an interpretation of the Serbian Ministry of Finance, a binding ruling, but it tackles comparable, not the situation as the one at hand. Namely, according to this ruling, the generator will perform one main supply, and that would be the transfer of the constructed object to the operator, and an ancillary supply that would be the land, and this auxiliary supply will share the VAT treatment of the main supply, meaning the facility. It can be expected that the same formula will be also applied to the situation where the generator transfers to the operator land plot with any facilities or a grid on it, meaning that would be the main supply, and the additional supply would be the underlying land plot. In such a case, another question would be, what is the chargeable amount? What is the taxable base for VAT? the Serbian VAT Act, in these situations of a barter arrangement, the chargeable amount is the market value of supplies of the operator that will be received in return for the transfer of land and facilities.
Mm-hmm.
Which means in this specific case, the chargeable amount would be the beneficial prices which are received for the energy, for the transferred land and construction works. Now, of course, the question is, how is it measurable? How many of these beneficial prices will form one chargeable amount? And given the situation that is not completely clear, it is expected that sooner or later the Ministry of Finance will be approached with a request for an explanation, for an official explanation, how these transfers will be taxed. Because according to the current status of our laws, there are more than one legal hold. So
Right.
it would be a explanation of the Ministry of Finance would be more than welcome in this situation. That we have a company and we have equipped it for operations. It will sooner or later start generating profits. Two short informations. Corporate income tax in Serbia is 15%, so that would be that the tax rate applies to the profits of the generators' companies. And an information that in Serbia, the Serbian Corporate Income Tax Act provides for a tax holiday of 10 years for large investors, and the large investors would be those corporations which invest at least approximately 8 million euros to their assets, which is fairly accomplishable by energy companies. Yet the second criteria might be an issue. The same taxpayer has to employ at least 100 workers for an indefinite period of time, which is questionable whether an energy company could accomplish that, since in energy everything is very high-tech, and everything is automated. But in case there was a company that sooner or later will end up with 100 workers, the 10 years tax holiday might be worth
Exploring.
Sure, yes.
Sure. Thank you. I mean, I believe that basically, especially renewable projects, having the requirement to have 100 workers employed on an indefinite period is hard from being, possible or realistic. But I would just like to state that there is a general possibility under both the energy law and, for example, the energy efficiency law, which allows the state to introduce a specific further tax incentives.
Correct.
Which is not yet implemented, but
Correct.
Hopefully will be. For example, in ESCO projects or related energy, renewable energy projects. So yeah, just to put a flavor there. Okay.
Thank you very much, Mr. Popovic, for this very in-depth analysis of the current legal and tax situation within the renewable energy market of Serbia. Ich werde jetzt wieder auf Deutsch zurückwechseln und wir beantworten jetzt gerne Ihre Fragen, die Sie haben. Sollten Sie noch weitere Fragen haben, können Sie auf jeden Fall auch unsere beiden Experten nach diesem Webinar kontaktieren. Wir schicken Ihnen natürlich auch gerne allen, die sich dazu angemeldet haben, die Präsentation zu, und gemeinsam mit dem Außenwirtschaftscenter Belgrad und CMS Belgrad stehen wir Ihnen natürlich zur Verfügung. Jetzt zu den Fragen. Gut. Dann werde ich diese eine Frage, die schon letzte Woche an uns gesendet wurde, als wir Ihre Links geschickt haben. Und zwar war das die Frage, und die kann man wahrscheinlich an beide stellen. Sie wurde schon erwähnt. I will switch now again to English. We're going to talk about the topic which a lot of Austrian companies are interested in, supplying goods. Parts to existing system, to a new system. So what do I have to consider tax-wise? What shouldn't I do? What are the biggest mistakes you see regarding to delivering goods tax-wise, and maybe also legally the implications to existing system which is being built at the moment? What could you give us? Just a brief overview.
I haven't seen much of no-nos in practice, but I did see that foreign companies are not very familiar with all the options they have. So there are no big downfalls, but for instance, some companies do not know that they can that they can register for VAT in Serbia, that they can act as importers in Serbia. Foreign companies who are participating in a project in Serbia and have their subcontractors, Serbian subcontractors, up until 1 or 2 years ago, have been charged for the services of the Serbian contractors with VAT. From the moment the VAT registration for foreign companies has been introduced, this VAT is not lost anymore as it used to be. But now the foreign company, once it has submitted, has registered for VAT, can also submit a VAT return, where it can deduct the VAT from its Serbian subcontractors from their own VAT obligation, which so far wasn't possible.
Mm.
Right.
Yeah. And on the legal side, I would say that there were a lot of customs-related, difficulties, which particularly related to the treatment of certain, classes of goods, and how to treat multiple supplies of the same good coming in multiple branches to Serbia. Also, from the legal aspect, it should be mentioned that the construction, business could potentially be done even by the foreign company. Basically, companies that are performing construction works need to be licensed locally in Serbia. So they need to get the construction license or the design license if they want to prepare design for the wind farm or a rooftop solar project, and they need to have a license in order to get involved in the construction works in Serbia. Now, usually that was impossible for foreign companies, so they needed to found the subsidiary in Serbia in order to be able to perform directly construction works. However, in most recent practice, the Ministry of Construction, which is the competent ministry, allowed the foreigners and the branches of foreign companies to be directly licensed in Serbia. That usually implied that their engineers will pass the specific compliance test in Serbia, and so far it was actually prevented. They were prevented to do that because the requirement of the Serbian engineering chamber was that the exam is in Serbian language. Now, finally, the government has recognized the need to have the foreign experts coming directly here, licensed, and they allowed the interpreter to be on the exam. Mm-hmm. So, just to conclude on that point, it is now possible to have the foreign contracting company directly performing works in Serbia and being licensed to do so.
Mm-hmm. Good. We also have now two questions here. Maybe we jump right to them. I will translate them, of course. We have one question which now goes into the feed-in tariffs. So one would be, which feed-in tariffs do you have for biogas, facilities up to 1 megawatt and above 1 megawatt?
Sure.
So that would be one question. We're going to go to the next question.
Sure.
Just in 1 second.
Yeah, I brought the legislation with me because I really it's hard to keep those data in mind. So basically, for the biomass, for the biogas or for the biomass? For the
That's biogas.
Biogas. Okay. So for the biogas, the relevant feed-in tariffs are. It's stated that the feed-in tariffs are dependent on the installed capacity, so they are dependent on the power of the relevant project. If the power of the project is 0 to 2 megawatts, the incentive price is calculated in the following manner. It's a formula. It's not straightforward. So we have the formula according to which 18.333 minus 1.111 times P should be the resulting incentive tariff. Now, it needs to say what the P stands for. So the P is the installed capacity of the power plant or the part of the power plant expressed in kilowatt hours. So in other words, for the biogas facilities of between 0 to 2 megawatts, we'll be having the feed-in tariff, which results from the equation where we have 18.333 minus 1.111 times the installed capacity of the biogas facility. I mean, we can maybe have the calculator and try calculating.
I would say we will translate the law and we'll send you according to the question. We can help you more, I guess, with that. And we already have it. We have our expert as well within our office, Mr. Boris Kostic, who will gladly contact you about this topic.
Yeah, and just maybe shortly to add that for the facilities of 2 to 5 megawatts, there is another formula, which is 16.85 minus 0.370 times P, and we said P is the installed power capacity in kilowatts, and now over 5 megawatts, it's simply put to be 15 euro cents as per kilowatt hour. So above 5 megawatts in power, we have 15 euro cents per 1 kilowatt hour price.
Okay.
In the last case, it's more simple.
Good. And we have one more question regarding to the feed-in tariffs with photovoltaic systems. If you could also enlarge on that maybe a little bit, if it's easy. Otherwise, we would also send it accordingly.
Well, it's also some sort of formula, but for the solar facilities that are on ground, it's 9 euro cents per kilowatt hour.
Okay.
And for the when they are on the facility up to 0.03 megawatt, they are 14.60 minus 80 times P, and when they are between 0.03 to 0.5, they are 12.404 minus 6.809 times P. So it's again a formula, but it's not really, I mean, we've all seen more difficult formula. We don't have integrals at least, so it's relatively easy to calculate, so we'll be happy to share this with you.
Definitely. We will send it to you in the next couple of days. Maybe one more question, which you also talked about, which was also sent to us beforehand. What are the risks? Maybe you talked about the incentive decree, that there's a lack of general rules of administration. So the question would have been, what do you expect now legislative? We have now this new package. What do you expect now regarding to those holes within the law, those the opportunities to bypass the law. Do you see the government as an active player in that?
Absolutely, yes. At least based on what the government so far did. It was really, I must say, to an extent, a surprise for me, because the government was willing to address certain very important stakeholders' concern and install it in the legislation. However, I would say, to answer your question, Mr. Gibbs, I would say that there are two ways of perspective going forward. One way is to simply interpret the regulations based on the existing rules in a manner to protect the legitimate interests of generators. One example is the following. Government was already in delay in issuing the 4P statuses under previous legislation. So it took 9 months for government to decide, for the Ministry of Energy. The reason for that is very specific. There were no comprehensive legislation in place, so probably government didn't want to to hurry up and then to provide for certain decisions that are not adaptable to the legislation that will be adopted. Now that the legislation is adopted, there are no reasons to expect that the government will be delaying in, for example, prolonging the 4P status. However, I believe, and actually this was already subject to discussions in certain projects. There is the question whether, for example, if the 4P holder, so the generator, asks the government to prolong its status, and the government fails to decide within 1 month, which is the statutory period, there is the question whether the generator again should expect this to happen with 9 months delay, or should do something about it, because this will now be in the later stage of the project, almost before commissioning. In our legal view, really, and that will be always our advice to clients, would be that in such a case, they use the general administrative rules and just apply for the negative silence of administration, meaning that if the ministry failed to decide within 20 days, they should deem that the negative decision has been adopted, and they should file for second instance proceedings with the government, not with the ministry. In other cases where the situation is more specific, I really hope and expect that the government will provide for more specific rules to govern, such as the one related to change in law that we mentioned earlier. So these are two ways, either to flexibly interpret regulations or where the necessity requires to have more specific rules, and I believe that will happen in foreseeable future.
Good, and maybe one last question before we end this, unless, of course, the viewers have some more questions. You talked about the cap space, which is already completely emptied out. So new investments, we have to look for a further enlargement of this cap. Do you think there's going to be a timeline, or is this, because this is a hot potato politically, I would assume. This is something which energy prices, for those of you who don't know, in Serbia are used as a political tool to an extent. So can we expect it in the future, especially for those who are interested in investment? Because those capacities are blocked.
Yeah. Expectation is that we should expect this to happen in the following 6 months. There are some rumors on the market that this should be limitedly allowed in respect of the wind and solar projects. It is not expected that this will go to double. For example, if we have 500 megawatts cap for the wind, it's hardly expected, but it would be great news for the renewable sector in Serbia that we come up to a 1,000 megawatts cap. But at least 50% should be increased, in my view, in the following 6 months. However, as we are hosting together the energy conference on the 22nd, which is that next Thursday here in Belgrade, and for those of you who will be attending that, we would expect some representatives of, high representatives of the Ministry of Energy to be there, if not the very minister. So maybe that will be the chance to tackle this topic too.
Thank you very much, Mr. Popovic. If there's no more question regarding the topic, I will switch back to German. Vielen Dank. Sie können uns natürlich auch weiterhin die nächsten Tage, Wochen Ihre Fragen stellen. Wir sind jederzeit für Sie erreichbar und auch unsere zwei Experten sind jederzeit für Sie erreichbar, wenn Sie Fragen haben. Ich darf jetzt das Schlusswort Frau Dr. Thiemann-Brenner übergeben, die Sie noch auf den weiteren Abend vorbereiten.
Danke herzlich für Ihre Aufmerksamkeit. Ich würde Sie noch gerne noch einmal darauf aufmerksam machen, die Energiekonferenz, die Herr Rechtsanwalt Popovic gerade angesprochen hat. Nächsten Donnerstag, 22. September, sollten Sie es Ihnen möglich sein, nach Belgrad zu kommen. Wird sicher eine sehr interessante Veranstaltung für alle in diesem Sektor tätigen Unternehmen. Noch einmal vielen herzlichen Dank. Das war unser erstes Webinar, wenn ich das so sagen darf, vom Außenwirtschaftscenter Belgrad. Und wir stehen Ihnen natürlich, wie schon erwähnt, für alle weiteren Fragen natürlich immer sehr, sehr gerne zur Verfügung. Danke herzlich und noch einen schönen Nachmittag aus Belgrad.